Good afternoon. Stephanie, are you ready for me to begin? Very good. I'd like to welcome everybody who has joined from the public and our panelists today for our very first public meeting under the O'Donnell Consent Decree. What I'm going to do is, Stephanie, if you could go to the next screen for today's agenda. This thing here. I am Jim Bethke, the Director of the Justice Administration Department. Today is our 1-year anniversary. Our department opened for business on October 28th last year. What we're going to do is I'm going to provide just a little bit of an overview of our office's role under the O'Donnell Consent Decree. Then we'll hear from Professor Garrett and Professor Thompson, our federal court monitors. We'll also hear from a representative, Rachel Frazier from the County Attorney's Office, and we'll hear from Major Doherty and Victoria Jimenez from the Harris County Sheriff's Office. And then we'll close out the panelists with Presiding Judge Cedric Walker of the County Criminal Courts at Law. We're anticipating the panelists to in total to spend about 30 minutes, and that'll leave us about 60 minutes for questions and answers. And we really do look forward to the questions we get and the feedback that we get from y'all. Regarding the questions and answers, or the questions, you can, what my staff has recommended is to send your questions via the chat. And then once Judge Walker finishes, Brianna Cummings will then post the questions to the panelists, and then whichever the panelist wants to answer, we'll answer. So with that, Stephanie, if you turn the screen. As I mentioned, our department began operations a year ago, and our mission is really to bring stakeholders together to facilitate meaningful improvements throughout the Harris County justice system that ensures public safety, fairness, equity, efficiency, accountability, so that all Harris County residents can live in a safe, healthy, and thriving communities. One of our big responsibilities is we are tasked with the implementation of the O'Donnell Consent Decree, working very closely with both Professor Garrett, Professor Thompson, County Criminal Courts, the Sheriff's Office, County Attorneys, and other key stakeholders. Next screen. This is the kind of the 10,000-foot overview. Professor Garrett will get into much greater detail, but the impetus of today's meeting began in 2016 when a class action lawsuit was filed by the plaintiffs, Alec Karakastanis and Elizabeth Rossi, the plaintiff's attorney. And they alleged that the bail practice in Harris County for misdemeanor arrestees was unconstitutional. After months and months of talks, the parties did reach a settlement. The parties in the lawsuit, of course, was the county, the sheriff, and the county criminal courts, and the plaintiffs. The settlement was reached, and the consent decree outlines the required changes that the county has made and will continue to make to its judicial processes. With that, what I'd like to do is turn it over to Professor Garrett and Professor Thompson. They began their work on early March, on March 3rd of 2020. Since then, we've met with them on at least once a week on a regular meeting with all the parties, and on various other aspects, probably sometimes 2 to 3 times a week, working really closely with our data team. The amount of effort and time that they've spent with us, the stakeholders and others, has been quite frankly amazing. And we're delighted that they are serving as our federal court monitors. And with that, I'll hand it over to Professor Garrett.
Well, it's really a pleasure to have this opportunity to meet with you all, and thank you, Jim, and thank you to everyone at JAD for all the hard work that you did to organize this meeting. It's not as easy to all get together during COVID as it would be otherwise, but I hope we can make this as participatory as possible. And I really hope that all of you who are watching this don't just sit and listen to us, but please send us your questions. We really want your feedback. We want to answer your questions. And so, my comments will not be too long. Sandy and I are thrilled to be partnering together doing this work. And like Jim suggested, sometimes 2, sometimes 3, sometimes 10 meetings a week, although virtually. There's a lot to do. And that said, there's been incredible work done already to create the architecture of this misdemeanor bail reform in Harris County, which is already a model for the nation. But we have work to do to implement this fully and to put the rest of the architecture in place. So to give you an overview, Sandy and I were appointed as court appointed monitors in the first week of March. And so we'd certainly learned a lot about the consent decree and met with the parties, read the document very, very carefully, many dozens of times before we started. We also started at an inopportune time, right? The first cases of COVID reached the Harris County jails basically then, early on in March. We began our work promptly and immediately began doing both formal analysis of data that we began to receive from the county, and also a lot of our own hand collection and observation, which I'll say a little bit about. But first I wanted to just say something about our team and have Sandy introduce you to our even broader team. Our narrower team consists of Sandy and I and some others. So I'm a law professor. I teach at Duke Law School. I work a lot with researchers, despite being a lawyer without a scientific background. Sandy and I have known each other for many years because of our work together on some issues related to both eyewitness evidence and forensic science, including work with the Houston Forensic Science Center, whose board Sandy has sat on. Also on our team is Dottie Carmichael at Texas A&M, and particularly at their Public Policy Research Institute. And her team is integral to our work in 2 different ways. The first way is that they are assisting constantly with the project management aspects of this work, and the project management at the counties on the county side has also been just superlative. There are a lot of deadlines, there are a lot of deliverables, there are a lot of details, because this is an agreement that lasts, our monitorship lasts 7 years. The agreement is a long-term agreement, and that project management has been intensive at times. So we've been incredibly grateful to have the partnership with the folks at PPRI, Texas A&M. A second piece of their work, which we'll talk about a little bit as well, has to do with a broader look at the cost and benefits of this misdemeanor bail reform. And not just sort of simplistically in terms of how many jail cells are filled or how many people with misdemeanor complaints come back into the system, but broader social costs on the community and certainly the budgets of the relevant agencies. And that work has begun and will be incredibly important as we evaluate how well this is working. Other collaborators include Dr. Songmin Kang, who has been invaluable in his help analyzing the data. A lot of the figures and tables that you see in our monitor report are thanks to him. We also have a broader group that has been advising us regularly throughout this process. So I want to turn things over to Sandy to introduce to you our community working group and our work throughout this process to get feedback, to run questions by, and to collaborate with community stakeholders.
So thank you, Brandon. As you noted, I'm a professor at and I've been a resident for the last 30 years. And like Brandon, in that time, I've and because of the great I'm delighted to be a part of this team. For many years, I had been doing advocacy in Austin, as well as in Houston, around the issue of bail and the impact that that money bail had on poor people. Make the money bail or not, there were implications for the working poor and groups like the homeless and foster children. Were concerned to me for years. To be part of the team, I have to say that knowing the kind of folks we were going to be working as well as the bench, and across, all the other stakeholders, the sheriff's office, the public defender, the district attorney, across the board in Harris County. I think we have some very strong that have really shown a commitment to working with us in this fundamental transformation of the pretrial justice system in one of the largest counties in the country. So it's really amazing what's has to 11 members in our community working group. This is a diverse group of individuals who are leaders in the community in different capacities. We have someone who works directly with the homeless. We have someone representing the downtown business community. We have someone who works with victims of sex trafficking, of domestic violence, immigrants, foster children. We have several who were top brass at HPD. We have civil rights advocates as well as individuals with personal experience going through the criminal justice system, sexual violence. And so it's a group that brings a lot of experience and a lot of knowledge about our community and about the issues that this very comprehensive consent decree addresses. And we've met 6 times with them by now, bringing various county officials, we've got regarding like community engagement, how to reach broader Houston area community. As concern about ethnicity in Harris County, gender and next month, in particular, the informed training for county officials, as well as in arranging other community meetings. So we have met now with a large group of individuals who represent advocates and service providers for survivors of domestic violence. We've listened to their concerns and gathered more insights about the concerns of that. We've also had a very large with the advocate and service providers for veterans, individuals with health and drug issues, etc. And once again, we learned a great deal in those. ODonnell Consent discussions about improving so to avoid having people and stepping into other programs that might help them turn their lives around. So we're very encouraged, and I think the things that was translations into languages of things like court notices and other forms and responsibilities, enormous progress. A lot of time to be translated. So, we're looking forward to continuing this work in the years to come. A lot of progress that we will be seeing.
Thank you so much, Cindy. I'm back and unmuted. We certainly don't see our community working group as a substitute for comments from the public. So please again, send in your questions and comments as we present to you. I just talk for just a few more minutes because I know we're running out of time. Our first 6 months of work was described in a long report. It's available on a website. We have a Monitor website. It's also on the county's website. It was filed with the federal judge that oversees this consent decree. Just to give you an overview of the highlights, well, we created a Monitor website. We completed our report. We convened the community working group. There was plenty of work to do that involved providing feedback on different policy improvements, decisions that the county made in terms of documents to share with the public. All that structural work is described in the report. We also had some initial data that we were able to analyze and present some results on. Some of it was hand collected. We were watching videos of hearings. We were copying down the text of hearing officer rulings. And so doing basically informal court watching to watch the misdemeanor process and get a sense of what was happening in cases. There's still a lot of data analysis work that is still in progress. But what we had was about 5 years of data on the misdemeanor docket in Harris County. So going back to 2015. What we described is that there's been a modest decline in the number of misdemeanor complaints each year. Back in 2015, it was more than 60,000 cases per year. It was down to about 50,000 by last year. This year may be quite a bit lower, but for COVID-related reasons. The share during that time of cases where a bond was approved and not a secured bond, a cash bond where someone might end up in the jail because they can't afford it, but rather a personal or general order bond, which results in the person's release to the community. That share has steadily climbed, and it went up much more so after Rule 9 took effect, which was the new rule that the County Criminal Court of Law judges adopted in February 2019. That rule was then incorporated into this consent decree. And so, some of the analyses we presented in our report is, well, what happened before and after Rule 9 was adopted? This important change in how misdemeanor cases are handled in Harris County. The main change, there are a lot of changes, but one big aspect of it is that for most misdemeanor offenses, a person is entitled to a general order bond at the point of booking and is released. For certain other offenses, which are called carve-out offenses that are comparatively more serious, like repeat drunken driving offense, a domestic violence offense, then the person is not automatically entitled to a general order bond. Instead, they have a hearing, but a much more robust hearing than in the past. They will be represented by a public defender, so there's a lawyer there, and the hearing officer must find by clear and convincing evidence that there's no other alternative to an unaffordable bond if the goal is to detain the person, or they can find that there's no other alternative to certain types of community supervision if the person work involved reading those opinions, getting a sense of how these hearings were proceeding and were they living up to the rigorous standards set out in the consent decree. We also reported on what the outcomes look like big picture, and we described how the number of jail days that people are spending is dramatically reduced. Far more people are receiving bond and released to the community. We also looked at how many misdemeanor complainants are brought in on a new complaint within 90 days, 180 days, and an entire year. And what we describe is that there's no change in that rate of new complaints during this time period before and after these reforms were adopted. We also looked at how often is it a new felony complaint or just the number of new complaints per person. And again, no change. Perhaps not surprising to those who had always thought that bail reform was a good idea, and that even before these reforms, it's not like people in misdemeanor cases spent lots and lots of time in the jail. There was great pressure to plead guilty to get out of the jail if you were in jail because you couldn't afford a cash bond. And so average jail stays, we show, were much longer before bail reform, but they weren't that long, 10 to 14 days. There's important work that we haven't done. So we're just now starting to get and examine data concerning, well, what happens in cases after magistrate or someone is released on bond? What happens as these cases proceed in the courts? There are other aspects of this consent decree which are incredibly important and will be implemented in the months to come. So as a preview of what's to come, the kind of criminal judges have adopted a new set of court appearance policies that were set out in the consent decree, but work is being done to implement those policies. Some of that implementation has been done. There is now an open hours court, for example, where people can come in person and reschedule court dates. The sort of data end, though, to actually record these new categories, the goal is to make it very clear when people are required to be in court and when the court dates can be rescheduled, so people know when they have to be there, when they don't, and what the rules are. There is also a new court notification system with the goal of making sure that people get the reminders like we do when we go to the dentist, so that people don't inadvertently forget about court dates and cause inconvenience to themselves and to the court. That process is being designed and developed, and that will happen over the next few months. So those are really important changes to come. We noted in the report that some initial calculations regarding just detention and jail cost, which is just one sliver of the costs that we're looking at in terms of assessing how well this is working. And we describe how there's been a modest decline in jail cost, but not as great a decline as you'd expect given many, many more people in the community. We did note that there's a small group of people, a very small subset, but that in that small subset, average jail days have increased quite a bit, and that's offsetting some of the cost savings. And that's something that we will be exploring further. So that's my big overview. We have a lot of work to do, and there's some really important pieces of this consent decree which are being implemented as we speak. And so there'll be a lot of exciting news to report to you next time we meet, both in terms of implementation and our data work and our evaluation. But we are extremely excited to be able to share what's happened so far. We think that it's already really, really exciting progress and really, really important, both for those of us in Harris County and those of us around the country.
We appreciate your time, Sandy and Brandon, today for going over that with us, and they'll be sticking around to the end. If we have additional questions, they'll be more than happy to answer it for us. Next up, we have Rachel Frazier from our County Attorney's Office.
Good afternoon. I'm from the Harris County Attorney's Office, and our office represents the county, its department, elected and appointed officials, and employees in civil matters that involve all sorts of county business. Our office also represents other departments within Harris County. If you can advance the slide, please. So I want to talk a little bit about criminal justice system reform in Houston, which is the nation's third largest county and has long been supported by both Harris County elected officials and local taxpayers who have paid to make the massive system more responsive to a diverse population, which is expected to explode to 5.6 million by the year 2025. In 2017, Harris County hired its first racial disparity and fairness administrator as part of MacArthur Foundation grant. And this post will focus on racial and ethnic disparity in the justice system and improve communication between the county and community, especially in communities of color. Also in 2017, and again, thanks to the MacArthur Foundation grant, Harris County hired its first ever in-custody population coordinator. Now, this post will monitor the inmate population and ensure that the county is using community-based programs and other avenues to keep the low-level offenders out of long-term detention. The person in this position is also going to make sure that policymakers are using the best tools they can and data to fight recidivism. So, the O'Donnell Consent Decree. The county attorney's office actively participates with the federal court monitor on a regular basis and plaintiffs' counsels on the changes being implemented across all county agencies. We are the legal resource for administering all requests for proposals, and we also provide guidance on data and information sharing to support the transparency. Thank you.
Thank you so much, Rachel, for that oversight. Next, we'll have our representatives from the Sheriff's Department. First, we will have Victoria Jimenez. She's the Director of Legal Services. And then we'll have Major Patrick Doherty. Thank you.
Thank you, Bree. My name is Victoria Jimenez. I'm the Legal Director here at the Harris County Sheriff's Office. And I've been the Legal Director here at the Sheriff's Office since March of 2020. I've been at Harris County since 2008, and prior to being the legal director here at the Sheriff's Office, I was in the Harris County Attorney's Office in the litigation division. In August of 2018, I performed a dual role. I was general counsel for the Harris County Institute of Forensic Sciences that houses the medical examiner and the crime lab, and I also had some litigation cases. I have been involved with the O'Donnell case since the sheriff came into the office in 2017. I was one of his two attorneys that helped litigate the case for him. Thus, I've been heavily involved with the conception and the implementation of the consent decree as it pertains to the sheriff's office and the jail. The biggest change for the sheriff's office regarding the O'Donnell case and the consent decree has been the processing of the general order bonds that Mr. Garrett was telling you about earlier for the misdemeanor arrestees. But with that, I'm going to introduce Major Doherty, and he can expand a little bit about the biggest change regarding the O'Donnell case and the consent decree as far as the sheriff's office and the jail is concerned. Major Doherty he leads the Justice Management Bureau here at the Sheriff's Office. He came to the county in January of 2017 after retiring from the Houston Police Department after 36 years of service. He is one of my all-time favorite mentors, teaches me a lot about law enforcement. So I will let him take the mic and tell and explain to you the biggest changes with the Sheriff's Office and the consent decree regarding the Sheriff's Office and the jail.
Good afternoon. As Victoria said, my name is Patrick Doherty. I'm the major over the Justice Management Bureau, which runs the Joint Processing Center. The Joint Processing Center is the center where all arrestees in Harris County come. They come through the doors here and then they leave. They go back to the community through the Joint Processing Center. Therefore, I'm very involved in the bond reform, how it operates in my facility. Most of the arrestees who have to go see a judge will see a judge here. They're charged while they're in my building. Once the charge is done, the newest thing to the bond reform is the general order bonds, where we can process those people out quickly. The most significant thing that the community needs to know is the Harris County Jail is the third largest jail in America. And right now we're about 94% full. And the bond reform has helped us use our resources as efficiently as possible to keep those in jail that need some protection, the community needs protection from them, and they're more serious, violent violators of the law. So the bond reform has helped us quite honestly, in our population from getting out of hand. We process people in approximately 300 a day prior to COVID and process out approximately 300 people a day out through various legal orders, bonds, and judgments of the court. That's about all I have to say.
We appreciate you, Sheriff's Department, for reporting out on the progress you've made throughout this bail reform. Next up, we have our county criminal courts at law, who's going to be represented by presiding Judge Walker.
Thank you. My name is Judge Cedric Walker. I'm the presiding judge of Harris County Criminal Court at Law number 11. I'm also currently serving as presiding judge of the Harris County Misdemeanor Criminal Courts, which we have 16 county criminal courts in Harris County that all have jurisdiction over misdemeanor criminal offenses. The first thing I kind of want to go through some of the milestones and benchmarks that have been reached in terms of bail reform, not only the consent decree, but some other things that we've done in the past year and a half, so to speak. So first, Local Rule 9 went into play on February 16, 2019. Local Rule 9 is essentially the rule that put into play the system of unsecured bonds being the primary basis for release in Harris County for misdemeanor cases for most misdemeanor arrestees. As Brandon said earlier, there are some people that don't get an automatic unsecured bond and have a hearing with a judicial officer while they're in custody, and then will come to the county criminal court at law presiding judge if that person is not given a unsecured bond by the hearing officer. Local Rule 9 is also incorporated within the consent decree itself, but it has been in effect since February of last year. The O'Donnell Consent Decree was signed by Judge Rosenthal on November 22nd, 2019. And as Brandon discussed, we've been going through the process of implementing that since, I guess August essentially of last year. I'm sorry, of this year. Also, the cite and release program we have is not incorporated within the consent decree, but it plays a big factor in the topic of bail reform as a whole. Cite and release is a program that allows law enforcement agencies to issue citations to people who are arrested or charged with certain offenses, misdemeanor offenses. And instead of being booked into the jail, they are then given a citation and given a court date to appear at a later time, rather than being booked into jail, potentially having their vehicles towed, or losing any other kind of things they may have at that time frame, and avoiding a jail stay, so to speak. There's certain offenses that this applies to: certain theft cases, criminal mischief cases, graffiti cases, certain controlled substances offenses. But again, it allows a significant number of people to be kept out of the jail. The sheriff's office has been on board with the program really from the outset. The Houston Police Department, obviously, which is probably the biggest agency in our county, certainly has jumped on board here in the last month or two. So we expect the increase in those cases to go up substantially and further, help keep people out of custody that don't necessarily need to be there. The other thing we've implemented that's been a big change, obviously, from the past years down here at the courthouse is the open hours court, which was implemented in September of 2020. That is a program that is provided by the consent decree that says that folks who have a warrant for non-appearance may come to a designated court every Thursday to ask for a reset of their court date. They can appear in that designated court, which may be any one of the 16, depending on the rotation for that week, or the person can appear in their assigned court if that court is available to ask for a reset of their court date if they have a warrant for non-appearance. There are some scenarios in which a person will have their warrant removed and get a reset. There are some other scenarios in which that may not necessarily happen, but a hearing has to be held first before the judge can make a decision on whether to not clear the warrant, so to speak. Have the next slide, please. Thank you. So what we've also done is made more of a concerted effort to waive court appearances when appropriate. Now, the COVID-19 situation has kind of really dictated that for us, so to speak. But I will say we were trending in that direction anyways. As those who've been experiencing the criminal justice system may know from years past, it was very common for courtrooms to be packed, potentially with 50, 60 people in the courtroom at one time. Certainly now with COVID, we can't do that, for health reasons, certainly. But even before that, a lot of courts were trending towards waiving appearances anyways, because the early stages of a case, it's not really necessary to be in court all the time. We've modified our court date notification forms to indicate whether an appearance is required or not. Again, for waiving appearances, we want people to know for sure, hey, your appearance is waived versus no, you do have to be here. We posted the court setting guidelines and procedures on our county court at law website. We're developing a web-based option for the defense attorneys and the arrestees to request or facilitate a request for a court date. And we're working with justice partners to develop a phone and email notification system for upcoming and missed court appearances. And we're updating the county systems to clearly indicate that a general order bond, which is an unsecured bond, is a personal bond for which the underlying amount is unsecured. Next slide, please. So as you can see by this chart, and Brandon's mentioned it in his comments earlier, that the stay in custody for misdemeanor arrestees has severely dropped. 2015, 0 to 1 day stay was only just over half of the number of arrestees. And now through June 30th of 2020, that's all the way up to 87%. So the new rules and the consent decree is keeping a lot of people out of custody, and they're not spending nearly as much time as they were under the old system. Next slide, please. And also you'll see that from 2015 to 2020, there's been a drastic increase in the use of unsecured bonds versus secured bonds, and also a drastic decrease in the number of people who don't get a bond at any point or don't post the bond at any point during before their case is disposed. So we've allowed people to get out of custody, go back to work, school, talk with their attorneys about the case before they make a decision on what they want to do, and not necessarily have to rush into doing a plea just to get out of jail. But again, thank you all for your time today, and I appreciate any comments or questions.
Thank you so much, Judge Walker. We appreciate your time and your guidance throughout this process. Next up, we're going to have actually our plaintiff's attorney, Elizabeth Rossi, who's going to provide us some further information about the progress of the O'Donnell Consent Decree.
Hi, everyone. Thanks so much, Bree, and thanks to you and Jim and Brandon, of course, and Sandy for coordinating this meeting. I don't have too much to add. I just wanted to introduce myself. My name is Elizabeth Rossi, and I'm counsel for the plaintiff class in the O'Donnell litigation. I'm really excited and pleased about the progress so far in implementing the consent decree. This is a landmark settlement with a lot of really exciting components of it, and it's a complex system to change. And of course, some of the practices and the culture within the system is extremely entrenched and has been sort of how things have been done for a really long time. And so I've been really pleased to see the enthusiasm and commitment of folks in the county and the sheriff's office and the judges and the hearing officers in implementing the consent decree. And I'm grateful to Brandon and Sandy for their very hard work and diligence in coordinating a lot of different people within the Harris County system. There's definitely a lot of work left to be done. There are key aspects of the consent decree that have yet to be implemented. There are aspects of Rule 9, the sort of cornerstone bail policy of the new system, which are not fully being complied with yet. But I will say that we're all working together in order to make that happen. And so I've been pleased with the collaborative nature of the project so far, and look forward to continuing. And that's all I'll say for now. I really think it's most important for you all to hear from the different defendant groups, and then also have everyone's questions answered. Thank you.
Thank you so much, Elizabeth, for jumping on, and we are happy to work with you as well. We did have a couple of questions that were posed. The first one, and panelists, feel free to jump in if you would like to answer any of these questions. Carol said, I thought I heard Brandon Garrett say some of misdemeanor defendants are detained. How's this achieved without a statute that allows preventative detention?
Yeah, and the quick answer there is that there is no such. A person can only be detained in the jail if a hearing finding that the only way, by clear and convincing evidence to assure public safety and with no other lesser, least restrictive alternatives, being able to make that assurance imposes a cash bond amount, a secured bond amount that the person cannot afford. And so it is only through an unaffordable cash bond that the person can be detained. And I think there's a related question about what role financial bail has in the system now. So financial bail does still exist. If someone is indigent, they cannot be, no financial condition under the consent decree, unless there is this very strong evidence. It's a clear and convincing standard, which means very strong evidence, not beyond a reasonable doubt, but really strong evidence that this is needed to assure appearance, to assure that public safety is met.
Can I just add to that, Brandon, if that's okay?
Please.
Yeah, of course. So I just wanted to make one distinction. One is that the federal lawsuit that we brought raised claims only under the federal Constitution. So we argued under the 14th Amendment that you can't detain someone pretrial without a robust hearing, counsel, and a factual finding on the record that detention is necessary. And we didn't bring a claim, although I think in another case you could. Constitution prohibits the detention of misdemeanors ever. And so that means that the consent decree really only speaks to what the federal Constitution authorizes or permits and what it prohibits. And because we didn't argue that misdemeanors could never be detained, there is a way under the consent decree and under Rule 9 that, consistent with the consent decree and Rule 9, people can be detained pretrial as misdemeanors. And the consent decree and Rule 9, again, take no position on what Texas law might permit. I think I agree with you, Ms. Oler, that under Texas law, you probably can't use unaffordable bail to detain people. But again, that wasn't part of the claims in this lawsuit. And so when we're talking about the consent decree and Rule 9 and what's authorized under federal Constitution, that's why Professor Garrett has referred to people being detained pretrial using unaffordable bail. And then I also just want to say that that Rule 9 cabins the use of secured bail. So for the vast majority of people who are arrested, secured bail can't be used as a condition of release at all. There are certain categories of people for whom hearing officers or judges can consider requiring secured bail. And for everyone else, Rule 9 prohibits secured bail as a condition of release at all.
Thank you so much to both of you for answering that question. Carol did have an additional question that I wanted to give to you all. Has there been an increase in the use of conditions that can potentially set defendants up for technical failures? Is this being monitored?
So I'll say, as monitor, data that we would like on what the different financial or non-bond related conditions are. So how many people, a protective order or drug testing and the like. Indigent people are not to be assessed with costs or fees for any such conditions, and that's a really important and positive requirement of this consent decree. But it's an area which we want to do more monitoring and observation. One way in which there are certainly, just by definition, more opportunities for failure is that, in the pre-bail reform days in Harris County, someone might be detained in the jail because they couldn't afford bond in a petty case, and they would plead guilty after 10 days, 14 days in the jail. Like what Judge Walker showed in his slide, you know, there were many more people in the jail for 10 or 14 days, but they would often plead guilty because it was the only way to get out. Now cases proceed towards the merits, but to actually bring a case potentially towards a misdemeanor trial may be many months. And so whatever conditions are imposed may be in place for many more months because cases are now going forward. And so I think it is important to look at whether the conditions are the right ones. The consent decree speaks to imposing the least restrictive conditions, the conditions that are needed. And that's something that we plan to study carefully. And it's a really important topic. I wish we could tell you more about it, but it's one of these areas where we're just beginning to get the information that we would need to get a sense of the practices.
And Bree, this is Jim. And one follow-up to Professor Garrett is there is a study that is being considered and taken a look at. So we're really hoping that study will help be able to address that specific question. You're muted. Bree, you're muted.
Thank you. Sorry about that. So I'll actually ask the next question. It says, it was actually directed to Judge Walker, but it says, tell us the failure to appear rates among those released on unsecured bond versus those released on a secured bond. And so as we previously discussed, we're still researching data to get that. The slide that he shows only took us to June 30th. So we still have time to analyze and validate that data. So we would not be able to give a definitive answer on that right now. If I'm missing something, panelists, feel free to jump in.
Bree, I would agree with you. I think we need more numbers on that to kind of make definitive conclusions one way or the other regarding, the difference between, the unsecured versus the secured bonds. Also, COVID-19, particularly for 2020, has really, really changed appearances just in general as a whole. So for the last, 6-7 months, data would be hard to interpret, I believe. Anyways, but I think, as you said, Ms. Cummings, that we need some more numbers on that to make a definitive statement about what the difference between the two is.
All right. And that takes us, it looks like we're running out of questions. If you look in the chat session also, Elizabeth Rossi has answered some of the questions that are being posed, which is our plaintiff's attorney. I'm going to go down. Okay. How does the Fifth Circuit Court of Appeals ruling that defendants have no right to be free from a wealth-based detention factor into implementation? And if you look down, Mario, Elizabeth has answered. It says the fact that Rule 9 authorizes pretrial detention using unaffordable bail is consistent with the Fifth Circuit's ruling that there is no right to be free from any form of wealth-based detention. All right, and those were all the questions that we had at that time. If there was anything else that the panelists would like to close out and to say at the community meeting, feel free to do so. If not, we'll conclude the meeting. All right, well, thank you so much. I would like to thank my boss and our director, Jim Becky. He's the director of Harris County Justice Administration Department. Professor Brandon Garrett, who's our federal court monitor, our deputy monitor, Sandra Guerrero-Thompson, our representative from the county attorney's office, Rachel Frazier, the director of legal services of the Harris County Sheriff's Office, Victoria Jimenez, Major Patrick Doherty from the Sheriff's Department, and our presiding judge, Judge Cedric Walker. Thank you all for your time. Additionally, if we didn't answer your questions or if you have further things, feel free to reach out to us on our social platforms. We do have our JAD website that contains the consent decree that also can connect you to the 6-month report and all of the updates that have been happening in the O'Donnell Consent Decree. Please like us on Facebook, Twitter, and then also if you would like to contact our monitors directly, they have a website below. Any additional questions or concerns can be directed to events@jad.hctx.net. We appreciate your time, and also this will be happening every 6 months. So please make sure that we got your correct email addresses. So for our next meeting, that all of you all can be present again. And if you have any further questions, we can answer it at that time. We appreciate your time today and have a great afternoon.